Have you ever really thought about what went down between Taylor Swift and Scooter Braun? I think everyone gets the gist of a record contract. And before we begin, look, I'm wearing my Taylor Swift shirt for this. It's a contract between the recording artist and the record label, where the recording artist promises to make a record for the record label, and the label promises to promote and sell that album for the artist. It seems pretty straightforward, but recording contracts can actually be pretty complex. In this video, I want to talk about how recording contracts work, specifically in regard to copyright law. And we're going to do it all in terms that we can all understand. In terms of Taylor Swift. I promise you don't need to be a Swiftie to benefit from this video. First of all, who am I? My name is Tiffany and I am a business and intellectual property attorney, and I work with creative businesses and small businesses to help take the overwhelming confusion out of the business side of running your business. Before we begin, a quick disclaimer, I am an attorney, but I am not your attorney. So the things that I'm talking about in this video should not be construed as legal advice, and I always recommend talking to an attorney who is licensed in your state. So with that, let's start. To understand all of this, we have to understand two things: the recording industry and copyright law. Again, we're using Taylor Swift as an example, but you don't need to really know too much about Taylor Swift in order for you to learn something from this. First, let's talk about the record industry. First, let's talk about the record industry.
You'll need to unlock your iPhone first.
In theory, since you own a copyright, as soon as you create something and affix it in some sort of tangible medium of expression, you could write a song, record it, sell it, and then collect 100% of the proceeds. The problem is, how will you get discovered? How will people know that you exist so that they can buy your product? That is where a record label comes in. Like I mentioned before, you could enter into a contract with a record label and they would use their power and money to promote you. So the idea is they will arrange for recording and then they will promote and sell that album, and in exchange, you will pay them a royalty payment. That all sounds great, right? But what's the catch? Record companies claim that it takes a substantial investment in order to break an act. So they believe in order to protect their investment, they should exert a lot of control over that artist. This is even more of a thing now that we're not selling physical items like records and CDs, and the streaming revenue is shamefully low. This is leading to more contracts that are called 360-degree contracts, where they can dip into all four revenue streams. Income from sound recordings, from songs the artist composes, which is things like commercials and licensing deals, income from merchandise sales, and live performance income. So they'll have provisions in the contract that grant exclusive control to the record label. But a lot of this comes down to bargaining power. A new, unknown artist is a bigger risk to a record label to invest in. And this means they're probably going to be unlikely to negotiate the best terms for their contract. Or they might just not know any better, or they're just so excited to sign a contract that all logical reasoning goes out the window. And really, can you blame them? In our example, Taylor Swift signed her first contract with the record label, Big Machine Records, back in 2006 when she was just 16 years old. Fast forward to 2018 and multiple Grammy Awards later, and Taylor leaves Big Machine Records and signs with Republic Records and Universal Music Group. You can imagine how the terms of these two contracts might differ, right? Back in 2006, unknown Taylor probably had very little bargaining power. Fast forward to 2018, and now she is a huge star, so you can imagine that she has a lot more control over what goes into that contract. Now, fast forward to 2019. Scooter Braun, who's Taylor's ex-manager,
which brings us to Scooter Braun,
has now purchased her former record label, Big Machine Records, and with that, the masters to her first 6 albums. To understand what happened here and why it became such a big issue, we have to talk about copyright law. Copyright law is a type of intellectual property that protects an original work of authorship as soon as that author fixes it in a tangible medium of expression. In order to qualify for copyright protection, the work has to be 3 things: original, creative, and fixed. I'm not going to go too deep into this, but if you want to get the scoop on all the basics of copyright, you should watch this video somewhere up here, and I'll also tag it down in the description. Basically, your creation has to be your own, it has to be original in some way, like you can't have just copied it from somewhere, and it has to be fixed in some sort of permanent form. So it doesn't apply to that song you dreamt of and never wrote down. Who owns the copyright? The person who created it is the copyright owner. And unlike patent law, you don't have to register a copyright in order to get the protection. It is protected as soon as the 3 elements above are met. Now, there's plenty of really good reasons that you should be registering your copyrights. I'm not going to go into it here, but again, you can watch that copyright video. For our purposes here, all you need to know is that the person who creates it is the copyright owner as soon as they create it and fix it in a tangible form. What does copyright protection get you? US copyright law provides copyright owners with the following exclusive rights: the right to reproduce the work, to prepare derivative works, to distribute the work, to perform the work publicly or display the work publicly, depending on what type of creation it is. Copyright also provides the copyright owner the right to authorize others to exercise these exclusive rights, subject to some statutory limitations. So copyright gives the copyright owner an exclusive bundle of rights, but to make this a little bit clearer in our minds, we're going to use the old law school standby of envisioning it as a bundle of sticks. So imagine you're holding this bundle of sticks as a copyright owner, and each one of those sticks in the bundle is one of your exclusive rights. One of the benefits of holding these rights is that you can license or assign each one of these individual rights to another person. But just because you give away one of those rights or one of those sticks, that doesn't mean that you're no longer the copyright owner. And that doesn't mean that you can't give out other sticks to other people. Now that we know a little bit more about copyright as a whole, let's talk about copyright as it applies to musicians using our example, Taylor Swift. When you record a song, you may be creating 2 different parts that are subject to copyright protection. You have the musical work, and then you have the sound recording. These are 2 separate copyright protected works that are subject to different rules, and they're commonly owned and licensed separately. The musical work is the song's underlying composition, so think about like sheet music. The sound recording is the specific recording of that song. So back when Taylor was still signed with Big Machine Records, she wrote the song Back to December for her Speak Now record. This is back in 2010. So she wrote the song and wrote it down, so it's fixed. So clearly she is the copyright owner. And then once she records it, she is the owner of the sound recording, right? Wrong. Here is the record industry rule. Whoever owns the master is the master. We're talking about master recordings here, or the original recording of an artist's original work. Basically, the entity that ends up owning that master is like the lord of that song for the rest of its existence. And this is in regard to things like visual media, live performances, and all those things like that. Like we spoke about earlier, this all comes down to bargaining power. The decision of whether or not an artist owns their own masters is a negotiating point when that contract is signed. And when Taylor signed that contract as an unknown 16-year-old, she signed away the rights to her masters to Big Machine Records. As a reminder though, remember that Taylor still owns the bundle of sticks. So just because she gave away that one right of her sound recordings to Big Machine Records, it doesn't mean that she's not still holding all those other rights in her copyright. What happened? So Big Machine Records owned the masters for the songs on those first 6 records that Taylor Swift released when she was signed under the contract with them. But when Big Machine Records sold to Scooter Braun's company SB Projects in 2019, that means that SB Projects was acquiring Taylor Swift's masters that Big Records still owned on her first 6 albums. This also meant that SB Projects could now enforce all those contractual obligations that were still remaining from Taylor Swift's contract from Big Machine Records. One of these obligations was a re-recording restriction, which barred her from re-recording versions of her songs until after November of 2020. So how exactly does that work? Remember, just because she gave away that right to the sound recordings does not mean she doesn't still own the rest of those rights. She still holds a copyright in these songs because there are 2 parts, remember? So just because she gave away the rights to that sound recording doesn't mean that she doesn't still have the rights to that song's composition. So she's still the copyright owner. Once her contractual obligation to not re-record those songs expired in November 2020, she was legally entitled to re-record any of those songs. And that's exactly what she did. To be clear, Taylor's new contract with Republic Records and Universal Music Group didn't have any prohibitions to her re-recording those songs as long as that pre-existing contractual obligation was no longer. And thanks to her high level of bargaining power at this point, she was able to negotiate that she would own the masters to all her albums that from that point forward, starting with the Lover album. So now, whenever you see that little Taylor's version next to the song title, that means that that is a composition where she owns both parts, the musical composition and the sound recording. An overarching theme of this whole thing is that artists should be able to own their own work in its entirety, and Taylor Swift was just in a good position to be able to get that message out. Unfortunately, this isn't uncommon, and it's kind of common in other industries as well. Like, movie directors very rarely own their own movies, and TV show creators rarely own their own shows. Instead, they get the promise of future profits. Essentially, this is a contract dispute. So, Big Machine Records and Taylor Swift entered into a contract, and technically, they both performed their duties under that contract. The issue lies in the disparity of the bargaining power between the two parties. You have a 16-year-old musician up against a record label. So no matter what industry you're in, remember the importance of knowing what you're signing. If you need help, be sure to talk to an attorney that is licensed in your state to make sure you are getting a fair deal. So that is it for today. I hope copyright law in the music industry is crystal clear now for you. I'm just joking, there's a lot more to it, but I hope you have a better understanding of the music industry and how record contracts work and a little bit of copyright law. Again, be sure to go back and watch that copyright video to get more information on the basics of copyright. If you have a recommendation for a future video topic that you want me to cover, please leave it down in the comments. And if you found this video helpful, please like and subscribe. That's it for now. We'll see you next time. Bye.